Thank you, Jocelyn, and good afternoon, everybody. And thank you for joining us today. As you'll know, we're recording this webinar, so if there's anything that you do want to go back over, you'll be able to recap or indeed pass this on to any colleagues who you may feel benefit from the content here. I'll be delighted to introduce Alice and Tim to you in just a second, but if I may, to give a little bit of background, we've had a significant number of calls and conversations with companies who are looking at the aspects of movements of individuals around Europe and how we make provision for that. From manufacturers moving product around Europe principally and needing to move staff around to follow the product. From a project management perspective, many companies are doing work outside the UK and are moving staff around to take briefings and implement projects. From a service and after sales perspective, there are also issues around that. And so delighted via our relationship with Make UK to introduce you to International Mobility Consultancy, and across to Alice Tranter and Tim Thomas, who are going to do their best to answer a lot of the common questions that there are that are focused around the issue of movements. And we're just having a quick catch up before the call, and there's a lot of detail and content in what Alice and Tim are about to present, and I think you'll both be quite happy to take questions during the presentation. So if you have anything specific, please tap it into the chat box and Jocelyn will interpret those and play them back at the end of the relevant sections. So welcome to Alice and Tim. Let me hand over to you, and we look forward to hearing what you have to tell us. Thanks very much for doing this today for the FEA. Thanks, Alice. Thanks, Tim.
Thanks, Keith. Thanks for the invitation. The webinar should last, well, we will be speaking for about 45 minutes or so. Happy to take questions at any time, Keith. We'll be looking at the trade agreement with the European Union, how it affects the movement of people and the provision of services, the movement of people's slots within the service element. We'll look at the rules in a little bit more detail, and then at the end have some practical hints and tips for what you can do. We're covering the temporary movement of UK workers from the UK into the EU and the rules that are going to govern that. So that's the topic for today. Keith, as you say, if anyone's got a question as we go along, tap into the chat. Interrupt us as we go. Happy to take all and any questions as we go along. Anything more detail we might need to arrange a separate call. We're always happy to help people. With that, I'm going to hand over to Alice. Myself and Alice cover this as a topic. We both used to work for Make UK for many years. We've been covering international mobility for, well, actually since the Brexit vote for a number of years. We both used to work in Brussels, so we know the European setup very well. And now we exclusively help UK businesses who have issues with mobility from the UK to the EU, or indeed the EU to the UK. We're going to turn our cameras off just during the presentation, and I'll hand over to Alice.
Thank you, Tim, and thank you everyone for joining us today. So without further ado, let's get started. So managing mobility in a post-Brexit world, business travel and service provision in Europe. So with all these things, we're going to start off with the trade agreement, because without the trade agreement, we would have to rely on previous rules that no longer apply to us because we've left the EU. So this came out on the 24th of December, Christmas Eve last year, implemented very slowly across this year, and even now some member states haven't fully adopted certain parts of the trade agreement. However, it is a framework for trade and services between the UK and the EU, and is a very good starting point to getting our heads around what has changed, what it means for myself as a UK employer or UK business, and what do I need to do now. So what does the trade agreement mean for the UK? So it's a framework, i.e. it's not completely binding in all its capacity. So it's a framework for trade, goods and services between the EU and the UK, which means whilst you can refer to it, other rules may take precedence. We'll come on to that in a minute. So the UK is now a third country By leaving the EU, the UK cannot get a better deal than it did as a member. So what that means is the treatment we received whilst an EU member state is at best the best we're going to get. By leaving, we will probably get something more onerous in terms of compliance and obligations from a business perspective. So the trade agreement, it explicitly allows each member state the flexibility to decide how they introduce parts of the TA because it's a framework. So they can choose which parts to adopt into their own national rules. So France can have their own national rules that exist at the moment, and they have their own set of rules for people coming in to work. If their own national rules differ from what the trade agreement says, that is no matter, because they can pick and choose the bits they like, or altogether reject it, and the French national rules will take precedence. So it's a framework. It's not the end all and be all. So each member state can adopt their own rules, as I just said, and have different processes and procedures for UK businesses. So you know what's coming. In practice, that means the requirements to enter or trade in each of the remaining 27 member states will vary and need to be closely checked. So that means 27 different immigration systems and 27 different countries' national rules on employment and local labour law. So it's a lot of new things to get our heads around. So the general caveats to be aware of. First rule of the trade agreement, it does provide market access for UK firms in the EU. However, there are several general restrictions that we need to be aware of. So it does not apply to public procurement in goods or services. So if you've got a contract with a client in the public sector, for example, oil, gas, whatever is in the trade agreement does not apply to those agreements. Tim, we have seen this in quite a few clients, haven't we, when they have wanted to send workers to Germany, for example, for work to do with the public sector.
We have, yes. So this is the public sector widely defined. Just be aware that, of course, in Europe, lots of things are still in public ownership that they aren't in the UK. So whether it's to do with the supply of electricity or supply of gas, but also the wider supply chain surrounding that. And if it's a public authority that ultimately is the consumer of something that you're contracting with or about, then that will be part of the public procurement exercise in France or Germany, which means that by definition that's excluded from the trade agreement. That could be the national government, or it could be a local government as well. So just be aware that those things aren't included in the trade agreement whatsoever.
So as I said before, each member state has the power to impose its own national and local laws. And in fact, individual member state national law does take precedence over the trade agreement unless otherwise notified. So for example, if German's national law on a certain type of worker differs from the trade agreement, then German law comes first, it takes precedence. So in essence, whilst the trade agreement is very useful as a starter for 10 to get a general idea of the framework or the general provisions between the UK and EU in terms of trade services, you will always need to check with the individual member state first before anyone travels, because their rules are likely to take place first over anything else. So unless an activity is covered by an agreement, then UK firms will need to visit WTO rules to find out if they have market access, which is in Chapter 4 of GATS Mode 4. So what that means is that in the trade agreement, we'll get onto this in a moment, the sector is split into 18. Under each sector, there will be subsectors and their activities. And if there is no restrictions next to the activity, you can fairly assume you're okay to perform activity in that member state, unless there is a restriction. And if there is this restriction, that member state will have had inputted that restriction in the trade agreement next to it. For example, if you're in the defence sector, you're going to Austria, they may have something along the lines of workers in the sector must take a residential labour market test before they travel. So we do not enjoy the same level of market access that we did before Brexit. There's still a route in, except there are now brand new provisions to be aware of. So moving on to trade and services, as I mentioned before, the economy has been split into 18. In each reservation, sector-related activities are coded, and then each code has different restrictions. Tim, do you want to say more about where to find codes?
Yes, I will. Where do you find the codes, and why are we talking about trading services? All the people movement elements of the trade agreement are in the services chapter. That's why it's important to remember, where do I start from if I'm moving people? I'm starting with the services chapter, and therefore if I go to the services chapter, I've got an economy split into 18 sectors. Each sector, as I said, has a reservation. The reservation is based on a code, so you need to know the code for the area of the economy that your business is operating in. Once you've got the economy, you know the sector or sectors you're operating in, then you know what the restrictions are on the movement of people. So unfortunately, it's quite an elongated process. The codes are publicly available. They're either UN codes or they're WTO codes. The codes are quite extensive, and bear in mind that you could be operating in more than one industrial sector under these particular codes. If you need help in finding the codes, please drop us a line or we can put it in the chat, the link to it. But that's where you start with the trade agreement. What is my code? It's called a CPC code. Then what sector am I operating in? And then what are the country rules for the movement of my people? And that's unfortunately the way that the TCA is structured.
Thank you, Tim. So yeah, so before you even need to think about whether anyone is traveling, you will need to refer to the trade agreement first to see what your sector is, what activities are covered by the trade agreement, identify your codes, as Tim has said, go back to the trade agreement to find your code and whether there are any restricted activities or national provisions there. So you do need to secure market access first to trade in your particular sector before you then send your workers. So a bit of homework first before any travel. So movement of people, so that's trade and services, and we're now focusing on the people element. So as we hinted before, the trade agreement cannot give the UK better or the same access to the EU than any member state. So history lesson, 1996, a directive was formed called the Posted Workers Directive, and this essentially regulated the travel of temporary workers, so within the EU. So if I was a French person traveling to Germany for a week to provide a service, the Posted Workers Directive would be the rule book essentially. And as the UK was a member state all those years ago, these rules did apply to us. However, UK compliance and UK awareness of these rules was incredibly low, and we never really complied very well. So the starting point is there are existing rules that regulate the temporary movement of workers within the EU. Therefore, if you're outside the EU and outside of the single market, it's very likely we're going to have at least the same rules, if not more onerous. And that is exactly what has happened. So firms established in the EU, they already do comply with basic labour market rules, as still do UK firms. And this includes when you send your workers to work in another country, not necessarily employed, but to provide a service to your European clients, for example, or whether you're doing work for a sister or parent company, you must abide by the labour market rules of that member state, which means paying the correct minimum wage and complying with the collective agreement. And I'm sure we all know what collective agreements are, but they have been negotiated between the relevant union to your sector and the relevant employers body to your sector. And as a result, a collective agreement has been produced, which rules what salaries must be paid to different workers in that sector according to length of employment and age. And this is right across Europe. Collective agreements are everywhere, and therefore you will need to identify the correct collective agreement that applies to your sector and your workers, so that even if they are only working for one day, they must still comply with that collective agreement, meaning they must be paid the relevant salary for their role in that region. The UK is also committed to continue to maintain current labour market and health and safety rules, but obviously as we go forwards, we may not choose to adopt future EU-wide labour market rules. So at some point we will diverge slightly. Worker definitions under the trade agreement. So they've come up with 4 new categories, some of which are more relevant than others. And these apply to UK workers travelling to the EU and EU workers entering the UK. So these are both ways. So what we've seen in the EU, they have created new routes in each member state work permits, normally under the title International Agreement Worker Route, which is simply one of the categories we're going to talk about today, which has been born out of the trade agreement. So you will see that in other member states. In the UK, on the other hand, in our brand new points-based system, our new immigration system, we too have a new visa route in called Tier 5, International Agreement Route. So that route has been implemented in the EU and the UK. And these new categories are business visitor for established purposes, independent professional, contractual service supplier, the independent international agreement route I was speaking of, and the intra-corporate transfer, so a secondment, so sending a UK employee to work for their parent or sister company in the EU for a period of time. Of course, each category has its own requirements to meet the definitions. You cannot just label yourself one of these. You will have to meet the requirements to qualify for these definitions. Again, sorry. Someone say something? No. Again, these definitions may not be necessarily adopted by all EU member states. So if France, for example, decides that your UK worker may qualify as a contractual service supplier, it may not be the same in Germany and so on. So whatever France deems your worker to be in terms of category of worker will vary across EU member states. As I said, they've got 27 different immigration systems we need now to navigate. Tim.
So business visitor for establishment purposes, best, I think, viewed as niche. We don't expect there to be many people traveling out of this category. This is an individual who can travel, for example, from the UK to an EU member state. They can travel as a business visitor or BV. As we go on later, we'll mention BVs again. The benefit of BVs, business visitors, is you travel without a work permit. But under this category, you're only there for the sole purpose of establishing a business. So what you can't do is engage in work, remunerated employment. You can't service your existing customers somewhere. You're establishing a new business. And you're there just for that and sole reason. You've got to be a senior personnel, you see in the slide, usually defined by salary length of employment. And that's an example of what Alice was just talking about. That will be down to the national rules. So in France, how they define senior personnel will be according to the French rules. And in Germany, it will be down to whatever the German rules are. So very much member state by member state specific as to how they define that. Now we'll cover business travel later, but just bear in mind what I've said. If you're in this bucket of traveller, then you don't need a work permit, but you will need some documentation at the border. And Alice and I will say some words on this later. The general rule is if you're travelling as a business visitor, you don't need a work permit. What you do need are documents that might be checked at the border to prove that you are a genuine business visitor for establishment purposes. And we'll go on a little bit later to explain what they might be. Independent professionals. I'll hand back to Alice for independent professionals or IPs. Broadly, we're talking about the self-employed.
Thanks, Tim. So if you're a UK business and you use contractors, for example, or those who are freelancers, or those who've got their own personal services company, which is quite common, you may use them to provide services to your clients in Europe as well as the UK. This model can no longer work. There are new barriers to this group. So within the trade agreement, if you're self-employed or a freelancer or a contractor or similar ilk, you can no longer provide a service within the EU unless you contract directly with the end client or the final consumer. So what that means is if the UK company uses that contractor to then provide a service to that UK company's client, that can't work because that is subcontracting. What would then need to happen is for the UK company to fall away and the contractor to provide the services as a direct contract between themselves and the European client. Now, obviously, no UK firm will do that because they will have just lost their European client to their contractors. So there's only a few solutions that can be put forward here. Either that contractor becomes employed on a temporary basis, perhaps by that UK company in order to provide the services into the EU, or they establish themselves in an EU member state, thereby overcoming that trade barrier into the EU, because we must remember we're now outside the single market. We've got to jump through these hoops in order to trade back into the single market, and that's why we're seeing these new barriers. And one of the biggest barriers is that if you do provide services to a European client, there must be a direct contract, and this is where a lot of companies are falling short, because in some cases UK companies don't even have a contract with the person they're providing service to in the EU. Whether it's a sold product, or whether it's warranty, or whether they are doing something else. Or they do have a contract, but they sell products to distributors who then sell on to the end clients, the final consumers, and that is not a direct contract. So Tim, we've seen this time and time again, where the contractual model of the UK business is the barrier here, rather than the actual mobility of the workers.
That's right. So frequently the way that manufacturing operates is manufacturing might operate through supply chains or distributors or franchisees or subcontractors or agents or something of that nature. And it depends exactly on what your contractual position is as to whether or not, we'll go through other categories in a moment, but this principle that you've got a contract with the final consumer is a common one in the trade agreement. So if you do have contracts with other businesses, and they go on to sell to a final consumer, then you will find the trade agreement provides little comfort for the movement of workers. If you're wondering what the final consumer means, because Alice and I do sometimes get questions on this, the final consumer is the person that consumes the product and does not sell it on for profit or gain. So if you're dealing with a company and you sell a part or a piece of equipment to a company, they then incorporate into something else and sell it on to a final consumer, you are not contracting with the quote unquote final consumer, because the person that sold it on has sold it on for profit or gain. A consumer does not sell anything on for profit. They're the person that actually pays whatever the final price is, and the product then finally sits with them and it doesn't get passed on.
Thanks, Tim. And the same principle can be applied to the self-employed, as we just explained. So the UK company, if they're providing service to a European client, aren't providing it directly, they're providing it via contractors that they've contracted with to then provide the service. So again, that is a form of the third party getting involved. If a self-employed person or personal service company worker does contract with a final consumer without a middleman, the contract cannot exceed 12 months, and they must hold at least 6 years professional experience in the relevant activity. So you do have to qualify under the trade agreement with those requirements there in order to call yourself an independent professional. Work permits and work permissions that allow self-employed workers to work in the EU to provide services do differ from those who are employed. So unfortunately, there's not one work permit that fits all. There's not one work permit that covers you for the entirety of the EU. You'll have to go country to country, sector by sector, region by region, and worker by worker, depending on what exactly you are doing. So it's very important you're able to categorize your workforce first before you think about mobility. So moving on to probably the best category in terms of enabling movement within your workforce, contractual service suppliers. The name is on the tin, so if you supply a service under a contract, this is you. So broadly speaking, it's the new definition of what we called a posted worker, of which the directed I referred to earlier, which is when simply an employer sends a worker on their behalf to provide a service in another country where they don't usually work. So many UK workers fall into that bucket. So this affects employees only, i.e. they must be employed, therefore it does not include the self-employed or agency workers. Apologies, there's a typo there. They must be providing a service as per their employer's commercial contract with the final consumer. So again, if you do not have a direct contract with the final consumer, your workers are not going to qualify as contractual service suppliers. They're going to be outside the trade agreement, and therefore you're going to have to rely and fall back on the member states' national rules to find a route in for your workers. There's many other things that affect that, but number one is if you don't have a contract, then immediately you're stuck at the first hurdle. If you do have a contract between the UK business and the European client, again, it cannot exceed 12 months. That's not to say you can never have a contract ever again, but you need to have it on a rolling basis and 12-month period basis. So to qualify as contractual service supplier, they must be with their current employer for at least a year, have at least 3 years professional relevant experience, and hold a relevant qualification if applicable to their job. So what we mean by that is that sometimes they will require a degree or equivalent. For example, if you're an engineer, you might have an engineering degree, or you might have level 4 H&D that sort of thing. Tim is going to explain a bit more about professional qualifications later, but there may be some issues in that area as well. As a CSS, you cannot receive EU remuneration. And again, if the service that the CSS is providing is not found within the trade agreement, then unfortunately you cannot qualify as a contractual service supplier. You're therefore outside the trade agreement, and you need to look at individual member state national rules in order to see what service you're allowed to provide, as we explained earlier, and then what route in does your worker need to find in order to enter that country and then provide their service. So moving on to the final category within the trade agreement, intra-corporate transfers. We see a lot of these happening. There's a common misconception that if I have a sister company in Europe or a parent company in Europe, I can send my workers to that company in order to do work without needing a work permit because I'm part of the same corporate group. Unfortunately, that's not true, and that does not apply. So if you do transfer internal employees to another employer within the same corporate group, there is obviously some requirements they need to meet in order to qualify as an ICT. Therefore, they have to be employed immediately preceding the transfer date for a minimum period of no less than a year if they are a manager or a specialist. However, if you're sending a trainee, for example, their minimum employment period with yourselves is only 6 months. When they refer to manager and specialist, they are senior employees who direct the enterprise or department, and they're allowed to stay for 3 years in the EU on a permit. Or a specialist is a much broader definition, so anyone within the company who has specialist knowledge essential to the firm's activity, and they are also allowed to stay for a maximum of 3 years. A trainee they refer to as a graduate, temporarily transferred for career development, and they're allowed to stay for up to 1 year. Tim, we see a lot of people with intra-company transfer type travel. Perhaps they're not permanently working for the company they're there, but they do go and visit their sister companies or parents companies quite a lot.
That's right. It's a very common method of travel, not just large companies, some smaller companies as well that might have satellite businesses or offices within somewhere in the EU. So this isn't just the large multinationals who will be familiar with the slide. This could be smaller UK companies that might have opened a small company, small branch office in France or Germany, for example. Just bear in mind when you go over and visit, if you're visiting your branch, your small incorporated company in France or Germany, you may think of yourself as a business visitor. You're actually an intra-corporate transferee, and you're in another bucket. You're in another bucket in terms of the migration we're talking about now. We'll go on to discuss business visitors later. If you are a business visitor going to that small company you set up in France, bear in mind that you're an ICT business visitor when you go. So again, that puts you in a slightly different bucket as well. So just bear in mind there is a difference between someone that's going to visit and someone's going to visit their business in that country.
And again, all subject to individual member state rules. So whilst the trade agreement provides this definition and these requirements, it may be interpreted differently in different member states in terms of who is an ICT. So again, always check with the national member state via the national website to see where your worker may be categorised. So moving on to business visitors, as Tim and I referred to, the difference between a business visitor and anyone else broadly who is going to be providing service or deemed working is that business visitors are therefore marginal activities, which is the term used in many EU legislation. So marginal activities include things such as meetings and conferences and attending things, and essentially not client facing and not performing any business activity that it would be deemed under your contractual arrangement. So we'll go through a list of things that business visitors cannot do as under the trade agreement, but do remember individual member states will have a different list of what business visitors can or cannot do for their country. Example being Austria. Austria probably has the shortest list of permissible activities for a business visitor. And again, if you're not on that list in terms of the activity you're providing, then you are likely deemed to be working and require a work permit. So most member states do provide an exclusive list of things you're allowed to do as a business visitor. If you're not on that list and you're not exempt from a work permit, then chances are you're likely going to be working from what they deem you are to be doing. It is not up to us to define ourselves whether we're a business visitor at the end of the day. It is what the member state has deemed you are to be. So examples of what you are not allowed to do as a business visitor. So you can't engage in selling goods or supplying services to the public. You cannot receive remuneration locally. You cannot provide any service other than that expressly authorised under the TA, and also whether that's been incorporated by the individual member state. Usually, if you're a business visitor, you shouldn't be requiring work permits, but you could be subject to border control. What we mean by that is that you can't just travel to France and say, hello, I'm a business visitor, take my word for it. You will be required to produce robust evidence at the border to show that you are indeed a genuine business visitor, you are there for the time you say you are, and that you are going to be returning to the UK again. And it normally means a long list of documents, such as your health insurance, a letter of invitation, your return travel tickets, proof of accommodation, and so on. So you do need to prove that you are indeed a business visitor, that you can enter that country without a visa and enter that country without a work permit. So as a business visitor or a tourist, who are both allowed to enter the Schengen area without a visa, tourists and business visitors are both allowed to stay in the Schengen area for 90 days in any 6-month period. When I refer to the Schengen area, it is a group of the EU member states, the majority of them being the EU member states, with the exception of Romania and Cyprus and a few others. Essentially, it's not 90 days per EU member state, it's 90 days the Schengen area as a whole. So if you do have members of staff who do travel frequently as business visitors and they tend to go on holiday to the EU, be aware that the Schengen area does log you in and out. They stamp you in your passport in and out, so they will know how long you've stayed in the Schengen area for. So do count your days. Short-term business visitors do not apply to local licensing, qualification, technical standards required for work. So what that means is normally, if I'm an engineer and I'm going to provide engineering services, normally I would be required to prove my qualification to do that, for example, my engineering degree. If I'm just going as a business visitor to have a meeting internally, for example, I don't need to be proving my qualification just to attend a business meeting. That's what that means. And again, obviously, individual member states can impose different requirements for short-term business visitors. Permitted activities. Again, this is going to vary member state from member state. However, this is the general list provided by the trade agreement, so you can get a flavour of what business visitors can and cannot do. So meetings, conferences and consultations, i.e. not customer facing, training seminars. So as a business visitor, you can go to the EU to receive training only in the form of observation and classroom instruction. You can't receive practical training, and you definitely can't provide training as a business visitor. Providing training is broadly deemed as providing service, isn't it, Tim? We've seen that in many member states.
That's right. So training is one of those areas which is quite difficult to decipher. If you're there to receive classroom-based training and it's not practical, then broadly that's fine as a business visitor. If you are or your workers are travelling into the EU to provide the training, to be the trainer, then that normally requires a work permit. And whichever side of the coin you're on, whether you're receiving or giving the training, if it's practical training, if it's vocational type training, then again, that normally would require a work permit. I'll also say a few words about trade fairs and exhibitions, as it's on the slide. Another popular one that there's lots of questions on, another one where the dividing line between, am I a business visitor? I can travel without a work permit. Am I not a business visitor? I require a work permit or a visa. Which side of the line am I on? Broadly, if you attend the trade fair as a delegate, you're there as a visitor. You don't have your own stand. You're clearly a business visitor. If you attend the trade fair because you are exhibiting, then the position becomes more complicated. You could normally attend the trade fair, and the key word there is to promote. If you're simply promoting yourself, promoting your business, and you're standing on a stand in a promotional capacity, all well and good. What it usually means in terms of the trade fair and exhibition is what you can't do is be engaged in direct selling. And certainly what you can't do is start the process of engaging people in contracts. The other question we get on trade fairs and exhibitions is, what about putting the actual stand up? Well, if you're there with, and the example that I normally give is a pop-up banner over your shoulder, then all well and good. if you're actually engaged in the work of constructing a stand and putting it together, and we're all familiar with what these tend to look like. There's an empty hall on day 1 and day 3, all the stands there. If you're actually taking your stand over and in the days before the exhibition opens, you are constructing the stand, then that's quite frankly normally work. I'll just finish this slide off as well, if that's all right, Alice. In terms of sales, representatives of suppliers can take orders and negotiate sales to existing companies, but you can't deliver. And bear in mind what Alice has already said, all these essentially are a menu of options. The individual member state can say, well, we're going to have the first, the second and the third, or none of them, or their own. So this is very much a pick and mix. You always need to check the individual rules for the individual country.
Thank you, Tim. So if you do need help deciding whether your workers would be categorized as a business visitor or not, please do drop myself or Tim a line and we can help you there, as it is a bit of the grey area, but usually the individual member state will provide a list of what they deem as activities can be carried out by business visitor or not. And if you're not on that list, and the activity you are doing is not on that list, then it is likely that you're not going to be a business visitor, but we can help all the same. More permitted activities. So after sales, after lease servicing. So this is worded in a way in the trade agreement which can be easily overlooked. So we do sympathise with those who read this and think that this is brilliant. A lot of my workers can now go as business visitors to that member state. So employed installers, maintainers with specialist knowledge essential to the contract, i.e. there has to be a contract in place, working under a warranty or service contract linked to the sale, lease of industrial machinery can go. So broadly speaking, if you're a UK business who's contracted with your European client to sell some machinery or a product or something of the same kind, and within that direct contract, you've got explicit clause allowing for warranty or maintenance work within that contract, you may send your workforce to then maintain or fix that machine if subject to that contract and in a warranty. If you do not have that warranty in your service contract, then you do not qualify for this exemption. And we say no member states implemented this yet. There are exemptions from work permits for this type of work. However, it is very strictly worded in a way that unless you do have that contract, you are employed, there is that explicit warranty clause, this exemption will not apply. And even in that regard, Tim, I'm sure you'll agree with what we've seen, not all member states have this exemption.
No, that's right. This is very much member state by member state. You need to check the exact wording, member state by member state. Some might be a little more flexible, some might be less flexible, and some member states won't have this sort of exemption there at all. The trade agreement says under a warranty or service contract, so it wouldn't cover commissional acceptance testing, that sort of thing. So whilst this is very helpful for manufacturers in general, it is very much on the precise wording of the individual member state. I'll just cover the last couple of bullets off on this slide. Commercial transactions, these are broadly aimed at the financial services sector, so they might not be just relevant to manufacturers. And just for any short-term business visitor that you're traveling, check the trade agreement and check the member state's national website for clarification for the exact things that you can and can't do. Just because it's in the trade agreement, don't assume that you can do it in that individual member state. And remember the last bullet on that slide, you'll always need to present documentation at the border, and that documentation will be aimed at checking that you are a genuine business visitor. So for example, if you sold a piece of equipment and you're sending a technician, then you are going to need a letter introducing him, a letter from the sending company, a letter from the client to show that they have invited the technician over, a copy of the contract potentially if it's a warranty or service contract, his return travel tickets, his accommodation, those sorts of things. So there's a package of documents you need even as a business visitor, even though you don't need a visa, to show at the border in order to successfully navigate the border and to prove that you are legitimately entering without a work permit as a BV.
Thank you. So that is business visitors and what they can and cannot do as a general provision within the trade agreement. But not to labour the point, we do have to rely on individual member state nationals to check what is allowed under a business visitor activity. So professional qualifications, I'm going to hand over to Tim.
Thanks, Anne. It's so easy to overlook, very important. You remember when we spoke about people like independent professionals, we mentioned qualifications. The UK qualifications awards are now not automatically recognised in the EU that they were whilst we were members, and our mobile workers frequently rely on their qualifications, particularly in regulated sectors. That's just not the obvious, such as aerospace and defence. That could be in utilities, that could be in food, for example, where individual member states require qualifications in order for workers to work in those sectors. Gaining work permits very often requires a qualification. It's like the UK, we issue visas. We prove competence by requiring people to have a qualification. EU member states do exactly the same thing. If you've got someone that's not a business visitor, they're probably going to need a work permit unless they're exempt. If they need a work permit, they'll probably need to have a recognised qualification. Contractual obligations might impose competence and qualification requirements on UK businesses, and from a practical perspective, if we're sending workers to the EU, we're less likely to win or retain business if we can't show we're deploying qualified workers. There's also insurance requirements. There's national or EU law, health and safety law, which may require workers to prove their competence. And again, proving competence is nearly uniformly by having a recognised qualification. Alice and I have come across some members whereby they're sending workers to the EU. They may be perfectly competent to do the job, but they're competent by experience as opposed to competent by qualification. Most EU member states, when they're issuing work permits, insist on the qualification as opposed to a period of time in service. So UK businesses now need to know what workers hold specific qualifications, what they are, and if they're going to be recognised in that individual member state.
Thank you, Tim. So moving on to another aspect of EU travel is social security, a chapter that perhaps is often overlooked, considering this has always been a requirement for UK businesses, but again, compliance and awareness of the subject was quite low, and so a lot of the UK employers will be faced with social security requirements for the first time, and it will be a new procedure for them. So essentially, whilst we were a member of the EU, we benefited from rules on social security coordination within the EU. So generally what this meant was that if you were paying NICs in the UK and you're employed in the UK, you could avoid paying additional national insurance contributions for the days that they then worked in the EU, whether they're a business visitor or whether they were actually providing a service. So this was a mutual recognition, both sides. So if Europeans came to the UK and UK went to Europe to work, they could avoid paying national insurance twice, essentially. So roll forward to 2021, when we've left the EU, it is clear that almost all UK workers would want to remain paying their national insurance payments in the UK for the days that they want to work in the EU, i.e. they would like to roll over this original agreement. And this is still possible, subject to following a process. So if you don't follow this process, and if you fall outside this process, then the general rule is, and the general principle is that UK employers and their workers must pay local national insurance for each day worked in the EU. And you do this normally in advance. So usually it's not possible to complete the pre-notification processes before travel without your proof of payment of the UK national insurance. And how we do this is that we obtain a certificate from HMRC via a gateway government portal login, and simply applies for a certificate. And when you apply for a certificate, they simply will check to identify you, are your name, your national insurance number, who your employer is, your personal details, the country you are visiting, and the dates that you will be there. And that is what you will need to upload, and HMRC will then give that worker or employer their certificate. It's informally known as an A1 form, but on the government website, they are known as CA 8835 forms. If anyone needs a link or more information around A1 forms, please do drop myself or Tim a line. So back to where we had that original agreement with the EU, i.e. that if you pay NICs in the UK, you don't need to pay it again whilst you're in the EU. Within the trade agreement, there is that general rule that local social security must be paid for the time a foreign worker is in that member state. However, within the trade agreement, there is a chapter on social security coordination called detached worker rules. So essentially, a detached worker is anyone who meets the definition below. An employee for an employer, i.e. a UK employer, for example, that normally carries out activities in the same place where the worker is employed, i.e. the UK, sent to work temporarily to another state, i.e. a European member state, for a period of up to 24 months, provided they're not replaced with another worker. So that definition can include most employees, essentially, who are sent to EU member state very temporarily to perform a service or even a business visit and then return again. That last sentence, provided they're not replaced with another worker, refers to chain posting. So an example of this would be, there's a project going on in the Netherlands, for example, you send one worker to provide a service, he then comes back to the UK and you replace that worker with another person to continue that service. That is called chain posting. And unfortunately, the exemption from having to pay Social Security by way of an A1 form falls away. The chain is broken. So essentially, the first worker you'd send out to provide that service with the A1 form, all well and good. If that worker is then replaced by a colleague or another employee, they will need to pay local Social Security. That exemption from paying twice then falls away. Tim, we haven't seen much chain posting really in recent customers or clients or members, but it's quite a important point for UK employers to take on board.
It is, yes. And when we say chain posting, we don't mean that person replaces, so worker B replaces worker A. Worker B doesn't actually have to go out the day after. If they go out a period of months after worker A, then unfortunately they're caught by the rule. You may wonder, how on earth is the country going to find out about this? Well, as Alice has mentioned, in addition to your worker needing potentially a work permit if you're sending them out to work and they're not a business visitor, in most cases, you need to notify the country, France, Germany, etc., that you're sending the worker. That's a legal requirement, we call it pre-notification. When you pre-notify, you've got to include a copy of the HMRC form Alice referred to, the A1 form as it's called. And when you pre-notify, you've got to give details of the worker, what job they're doing and where they're doing the job. That then allows clearly the country you're sending the worker to realise that you're actually sending a replacement worker. You're sending worker B, not worker A. And that allows them then to collect the national insurance contribution from you for worker B from day one that you send them. So yes, it happens. Rotational workers, they don't actually have to rotate. Worker A comes back one day and worker B goes back the next. There can be a gap. Just be aware of the rules.
In terms of the different A1 forms, there's broadly two types. There's a single state A1 form, which the majority of UK workers will need, and a multi-state A1 form. It's very important not to get the two mixed up. A single trip A1 form means you are flying out to a country and coming back again, or you're flying out to several different countries and coming back again. You will need an A1 form for each trip. A multi-state A1 form is different. A multi-state worker who requires multi-state A1 form is for those workers who are employed outside of the UK as well as the UK. So quite a niche group of people. It would mean that you are employed in Spain as well as being employed in the UK. And that would not normally apply to workers temporarily moving between member states to provide service. They're not multi-state workers. A multi-state worker is someone who spends more than 25% of their time in the EU as opposed to the UK and is deemed to be employed in another member state in addition to the UK. So it's very important that UK employers do not fill out multi-state work forms if their work is going to multiple EU member states. That's not what it's for. It's for those who are employed outside the UK as well. So if you do have several employees who do travel to multiple EU member states, I'm afraid they're going to have to get a single state A1 form for each country or each trip as they are not multi-state workers. They're not employed in multiple states. That's what that means. So moving on to penalties, fees and fines. As Tim mentioned, how on earth does the EU or Schengen area enforce all of these rules? Well, under the trade agreement and in previous legislation, each member state has the power to impose fines and penalties and require fees to be paid in the absence of compliance. So check the national website for each member state before travel to see what fees are payable and what processes they require. The fees I mentioned are those required for a visa or permit or something similar. When we travel to the EU, for example, if you're a business visitor, obviously your papers will be checked at the border and you'll be stamped in and out of your passport when you enter the Schengen area. So they do log you in and out. If you're going to provide a service, then sometimes there's a much more formal notification process, which Tim has referred to, i.e. you've got to notify that member state in advance before you send your workers, normally via an online portal. So if you do not comply with the advance notification, or you don't comply with paperwork, or you don't get the necessary work permissions, you will be easily found out. Because if you do provide that advance notification, it is very common for member states to send a local labour inspectorate round to the site of work to check that you've got the correct paperwork and to check that you are indeed complying with the local labour market rules. And if you're found to have not complied with the union law, this can result in fines and sanctions for both the sending employer, i.e. the UK employer, and the receiving employer. So that would mean your European client. So if the UK employers incorrectly sent their workers by not having a work permit, for example, the client is at risk for getting a fine as well. And the fines on average are approximately between 10,000 and 15,000 euros per worker. So the worker won't get fined there on the spot. The employer will. They will receive the fine. In terms of penalties, there is a scale here. So at the bottom end of the scale, if you have inadvertently forgotten your A1 form at the border, you'll get a slap on the wrist. Worst case scenario, you might get turned away at the border, and then you are logged on the Schengen system as being refused entry, which means you've lost your visa-free entry to that member state, which would then result in a very unhappy employee with their employer for not ensuring they travel correctly. At the other end of the scale, if a UK employer is found to have actively misled the border police or have actively misled any other authority and effectively not been truthful about the purpose of the visit, then you can see much more serious sanctions, such as the fines or even being taken to court, or in the very, very worst example, be banned from trading with that member state entirely. Tim, I think we saw a previous member fined around about 32,000 euros.
Yes, it does happen. We know of times it has occurred. We've got a very strong network throughout most of the European Union in terms of sister trade associations. We know that these fines are levied. As Alice explained, they are enforced by, you have to make the declaration, the advance notification, and labour inspectors. And we know that the fines are enforced, and they're part of a pan-European system. So just be aware that compliance with the rules is extremely important.
So that was a brief overview of the changes that start off with the trade agreement, then individual member state national rules, as well as professional qualifications, the categories of worker, the social security elements you must take into account, and lastly, the enforcement of these rules and the penalties for non-compliance. We've put together planning for travel, which should help UK employers prepare and organise themselves before thinking of sending anybody to the EU in the matter of business. So where to start? We'd recommend this to all members, is to ask yourself these key questions. So do you have the legal right to trade in the EU and provide services? This means going back to the trade agreement, as Tim explained, and finding your sector and finding your code and securing that market access. What do you already know about your workforce? Do you know who travels? Do you have a logbook of travel? Who organises the travel for your company? Is it the individual person's responsibility? Does HR have that overseeing it? Or do you outsource this to a travel company? Does your travel company that you outsource it to, are they aware of these changes? Are they aware of these new rules? Do you know who travels and why? Do you have the required knowledge internally? Are there others in your company that know these rules? Or is it just yourselves attending today? what processes should you follow for your workers to travel? Are you confident that you know which employee is a business visitor and which employee is a worker or a service provider and requires a work permit? Are you confident that you know how to navigate websites and apply for visas or permits? Do you have a budget for this? Visas and permits cost money. Some cost €500, some cost €60. Can you afford to purchase these work permissions when you send your workers? Do you have a budget for outsourcing this to help? Do you need to get some external consultancy advice? How long will it take to prepare for travel? So if you are used to sending someone at 24 hours notice, bear in mind that may not be able to happen anymore. Do you need to review your contracts to determine that it may take you 2 months to send someone? Because if you apply for a work permit, that can easily take 2 to 3 months, depending how long the embassy gets back to you. So do bear in mind, there's a lot of preparation to get in place initially, but once you have the right documentation in place, you've got files, you've got some good information about your company, your workers, then there should be some elements of flexibility about the repetitive nature of this. What you need to know about EU immigration systems, Tim?
Yes, so what do we need to know and what do we need to find out? Well, bear in mind a visa is just a permission to travel. It gets you through the airport, gets you through passport control. It doesn't allow you to do anything once you've left the airport. The work permit is frequently what you need if you are a worker traveling to the EU and you need to do something other than a business visitor. And we've explained what those categories broadly look like. So separate in your mind visa from work permit. Bear in mind, if the traveller, the worker is going to be in that country for generally more than 3 months or 12 weeks, they're probably going to need a residence permit as well. That's common throughout the EU. But some countries tend to mix the language, for example, the Netherlands, where it's a combined work residence permit. But in your mind, when you've got someone traveling, think when it says visa free, that does not mean to say work permit free. So you've got a visa, a work permit, and a residence permit. Then on top of that, the notification systems that we've just been explaining. So if I'm going to do some work and I need a work permit, then probably I'm going to need to notify in advance as well. All countries actually have online portals where you upload the evidence. So that's the takeaway from that slide.
So expanding on visa-free travel to the EU, if you are a UK traveller and you're a business visitor or a tourist, you can travel without a visa to the Schengen area for up to 90 days in a rolling 180-day period. So the 90 days includes all purposes, as I said, tourism as well as business visits. It applies only to the EU Schengen states, and the Schengen states are listed below. That is majority of the European member states we refer to. However, the countries not within the Schengen area have a copycat version. So other member states such as Romania and Cyprus, whilst they're not the Schengen area, they also have a 90-day stay rule, except that can be aggregated separately to the 90-day stay you will gain in the Schengen area. So do be aware of that. And yes, the EU do count the days and can exclude those who overstay. So if you overstay your 90-day stay, they can effectively bar you from re-entering without a visa if you do so. So they will stamp you out your passport. They will log you onto the online Schengen system, so they will know exactly when you do enter and leave the Schengen area. So be aware and count the days. And that is the end. We are right on time for an hour. If anybody wants to stay on for questions, we'll be more than glad to take them. Thank you.
Thank you very much, Alice and Tim. At this point, there haven't been any questions in the chat box. Perhaps if somebody does have a question, they could unmute themselves and just go ahead and ask it. It'd be a bit faster than typing it into the chat box. But I will say that it was quite thorough, so there may not be any questions. The information was very detailed and helpful. Thank you.
Hi, this is Jeff Fishlock.
Hi, Jeff.
Hi, just a quick question. I used to take our dealers' customers to our factories in Germany and Finland. What would be the requirements to do that again?
Sorry, Jeff, did you say you were visiting dealers and customers?
No, our dealers in the UK.
Yeah.
I work for a German company.
Yeah.
So I used to take dealers on regular trips to the factories in Germany and to Finland.
Oh, so these are UK dealers going over.
Yes, to look at the product
Yeah.
in the factory.
Yeah.
What situation on that?
So these dealers that are coming over, when you say dealer, are actually selling the equipment? Do they buy the equipment from the company?
They buy it from us. Yeah, they buy it from us.
Yeah, so they're buying from you and they're selling in the UK and they're traveling over there to see what the equipment is.
Yes.
That sounds like they're business visitors. Sounds like they're not a service provider, as we've explained. The answer is check German rules. It's sort of looking at some of the issues we've looked at here, Jeff, in reverse, if you like. So these are UK buyers traveling into the EU, essentially.
Yeah.
Yeah. In general terms, that would be a business visit, with always the caveat, I'm afraid, Jeff, which is check the national rules. But that sounds like that's going to be work permit free.
Okay. Okay.
Which is the answer you want, actually.
Yeah. Yeah, it makes it a lot could be making it a lot easier later on. Yeah. Okay. Thank you very much.
Does anybody else have any questions while we've got Alice and Tim, or we'll close the meeting?
If there's anything afterwards, Keith, please, you've got our details, just by all means, punt it through to us, fire it through, and we're happy to help today or afterwards.
Yeah, and if I may, Tim and Alice, on behalf of the FEA and all of us on the call, thank you very much for such an informative, clear and concise presentation of what is a very complex area. It came across very well, and
Yes.
You've answered really all of the key points that I've had questions on over the last few months, and it shows the complexity of work. And I'm sure if anybody does have any follow-up questions or elements they want to dig a bit deeper on, they're welcome to get in contact with you both, if that's okay, or do it through Jocelyn or I within the secretariat, and we'll pass them on. But I don't think we were quite as aware of all of the nuances and variances there were until we saw the presentation. So I think forewarned is certainly forearmed, and the complexity of the new requirements are very different. And I think we've seen that from a UKCA compliance point of view. I think the people element is even more complex and multifaceted than that. So really just leaves me, I think, to close the meeting and say thank you both very much for the information you've put across so well today. And we'll be in touch if we have any further questions, if that's okay.
Thank you very much, Phil, for hosting us today. Very kind.
Okay. All right. Well, we'll draw the meeting to a close. Thank you, Jocelyn, for coordinating everything.
Yes, indeed.
Thank you all for joining, and we'll see you at the next one.
Okay.
All the best, everybody.
Thank you, Keith.
Thank you all.